The petitioner in the election 2020 petition came to court with a number of applications, including a review of the court's earlier ruling on its request to serve interrogatories on the EC. The petitioner was also seeking a stay of proceedings until this particular application for a review was heard. But the petitioner had failed to file his witness statement. Now the court, after hearing counsel for the petitioner, ordered that the petitioner goes back and files his witness statements by close of day, Wednesday, 27th January 2020. My colleague Sixtus Don Ulo sat in the courtroom throughout the entire proceedings and has filed this report.
For the Supreme Court, Tuesday's hearing should have focused on the substance of the election petition as filed by former President John Dramani Mahama, but this was not to be the case. First, lead counsel for the petitioner, Chachu Chikata, was late to work.
May I respectfully crave your indulgence, if I may, to kindly stand the matter down a few minutes for Mr. Chikata. He's the lead counsel. He's prepared to argue this case. But he tried to get in touch with me. I believe he's heard that. Very respectfully.
Counsel, the official time is 9:30. Yes.
I appreciate that.
There are applications on record which is coming from your chambers. And obviously, you appended your signatures to all the processes. Yes. Can you...
I appreciate that, my Lord.
Then there was the petitioner's failure to file his witness statements as well as his written arguments.
Mr. Leader.
Yes, Lord.
You mean stay of proceedings means don't file processes. But meanwhile, you have filed processes. Even yesterday, you have filed the process. So how can you tell us that your stay of proceedings means you choose and pick which processes you can file and which you cannot file?
But if I may clarify, the processes that were filed yesterday were in relation to the review.
The petitioner had earlier filed an application for review of the court's ruling on his interrogatories, pursuant to which he had filed an application for stay of proceedings. Mr. Mahama's lawyers had additionally put in two requests for the Electoral Commission to 1. Admit to certain facts, and 2. Allow the petitioner to inspect the original copies of some documents resulting from the December poll. That notwithstanding, the court did not take kindly to the petitioner's failure to comply with orders on the filing of witness statements.
Yes, my Lord.
You filed this petition. You came to court with your petition.
Yes, ma'am.
You submitted your course of action and your reliefs in your petition. So you know what you are doing here. Is that not it?
Yes, madam.
And you indicated that you have 5 witnesses.
Yes, ma'am.
And you've been requested, directed by this court, just as all other counsels, to file your witness statements. Why have you not done so?
My Lord, that's what I've tried to explain, that subsequent to the order, we filed an application for stay of proceedings, and there is a genuine concern that that application would be undermined if we took fresh steps in the matter, and that is the reason why we have not filed it. And particularly when the view is that the review would, if granted, would impact on the kind of witness statements that we would file.
A lawyer for the petitioner, Tony Letha, also got the bench agitated with his comments on prejudice.
When the view is that the review would, if granted, would impact on the kind of witness statements that we would file, unless, of course, the suggestion is that the review is already predetermined, and therefore
Mr. Hita, don't do that. Don't do that at all.
I'm not
do that.
I withdraw that.
For the court, the consequences of not complying with the court order are strict and dire.
Order 32 Rule 7(8) Sub 3 of the High Court Civil Procedure Amendment Rule 2004 CR 87, which governs trials in the High Court, has a similar provisions as follows. Where a party has failed to comply with any of the directions given at a case management conference or pre-trial review or both, the judge may make any of the following orders. A. Strike out the action if the non-complying party is a plaintiff. B. Strike out the defense and counterclaim, as the case may be, if the non-complying party is a defendant. C. Order any party to pay cost. Or D. Make any the appropriate order. End of quote. The petitioner is again directed to file his witness statement on the matters raised in his petition.
However, prudence and justice will also make room for second chances.
The petitioner is again directed to file his witness statement on the matters raised in his petition and other pleadings, and his response to the preliminary objections by close of the day on Wednesday, the 27th of January 2021, failing which this court will proceed to invoke the sanctions imposed on this court by the rules of court. The petition is thus adjourned to Thursday, the 28th of January 2021 for hearing.
I must say that as practitioners of the Supreme Court and as lawyers who attend to court regularly, we need to exercise a little bit of restraint in the choice of our language. It's very important because at all material times we are officers of the court. It's unfortunate the language used by my good friend Tony Lita this morning was a bit offensive. To say that an application before the court has been predetermined, to say the very least, that's unfortunate, coming from my good friend, of course, and a very senior member of the bar. And very lenient to the petitioner, because they've been given another opportunity to rectify the wrong. The petitioner has been ordered to file his witness statements by close of day tomorrow. We are all legal practitioners. The Supreme Court is a very busy place. The Supreme Court is not a forum for organized, rehearsed, and choreographed theatricals or melodrama. It's a place for real, hard, and serious legal work. It's not for flurry of literature, long prose, and rather dull English, devoid of any legal merit. I want to advise my colleagues on the other side that if it ain't broken, don't attempt to fix it. We are ready for them on Thursday.
Our disappointment with respect to the language used this morning by a senior member of the bar and former president of the Greater Accra Regional Bar, Mr. Frank Davis. The language that he employed this morning is unacceptable in describing the actions of petitioners' lawyers as theatricals, in describing us as persons who intend to be intransigent and disobedient to the orders of the court. I am sure that Frank Davis knows, Mr. Frank Davis knows, that all the applications that we have brought are within the framework of the law. You are journalists. Please do a bit of research. Read CI 99. And please tell us where in CI 99 it is said that you cannot bring an application for stay of proceedings. There is a fetish that is being made of 42 days stipulated by law for this trial. Again, I want to refer you to CI 99, which is the amendment to the Supreme Court Rules CI 16. Go and look at Schedule 2 to CI 99. The schedule is very clear that the trial is supposed to take place from January to March. Now just do a bit of computation. January has 31 days. If February is not in a leap year, it has 28 days. And then March has 31 days. That's 90 days for you. Was the lawmaker wrong in stipulating this period for a trial? The view we have taken of this matter is simple. That the trial is supposed, the 42 days is the number of days, working days, that the court is supposed to use in discharging the petition. It is not to be computed on a day-by-day basis. I also wish to make it abundantly clear that this is far from being a frivolous and vexatious petition that His Excellency John Dramani Mahama has filed.
So that was a member of the legal team for the petitioner, Dominic Ayine, there addressing the media, expressing some concern with language used by, of course, lawyers for second respondent in the court, suggesting that the petitioner and his team were engaging in some theatricals to delay the progress of the hearing. We have a member of the legal team for the petitioner here with us, Mr. Eduji Tamaklo, and he's going to help us get a better understanding of what transpired in court today.
That review, until it is heard, we believe we cannot take any fresh action or step. And that is why, with greatest respect to their lordship, we indicated to them that we have no intention whatsoever to disobey their orders. What we felt was that, having applied for a stay, and the stay relates to a review, if the review is granted, then we can administer the interrogatory, the 12 questions on the EC. Once that is done, it will even tell us that we don't need all our 5 witnesses indicated in the petition. We may just come with 1. That's enough for us. And so we're simply saying that until a determination is made relative to the review application, just bear with us. In any case, the review is just Thursday. Once it is heard, we will take it out from there. Nothing more, nothing else.
But then the legal team of the second respondent believes that your inability or failure to file your witness statements is in clear defiance of the orders of the court.
I didn't get that impression from their lordships. Their lordships were willing to permit us to file by Thursday. We will not take any lesson on how to conduct our case from the lawyers for the second respondent. At least we have practiced law with each one of them, and we know how they do their practice. We will not take a lesson from any one of them. No. If it's about delay, we know people who delay cases in court. We don't. We have not used anything that is not warranted by the rules of court. That's their thinking. That's their mind. They are entitled to express an opinion. But we will not take a lesson from people like them. Why? Were they not the lawyers for the then petitioner, Mr. Akufo-Addo, in the last election petition? How long did they stay in this court? 8 months. We will not take a lesson from them.
We're now going to engage Minister of Information designate Kojo Opon-Nkrumah to give us what his thoughts are on what transpired earlier in court today. We've heard the legal team representing the petitioner address the press now. They have taken exception to some words. What do you make of this?
In all humility, this is not the first time we have said that this is theatrics for the cameras that are here. I think last week we mentioned it. It is our honest, very humble belief that, as my colleague Faisal said the other time, what they are doing is 15% law, 85% propaganda. It's the theatrics and how to, drag the issues and introduce new applications so that they can be talking to their supporters and the public and gradually letting them down. That's what they appear to be interested in.
They accuse you of saying.
Well, but that is exactly what they are doing. We have come to court because they invoked the jurisdiction of the court on the 30th of December and told the court that they have evidence to show that nobody won. This is very different from their initial announcement by Mr. Mahama himself that he won. And you hear them misinterpret our expression of surprise that, are we saying it is illegal? I don't know who said it is legal. Our councils have not said it is legal. It is perfectly legal to file applications. But it is clear on the face of what is transpiring that the issues have been settled. Now let's go to the issues and prove, and they consistently come with these interlocutory applications. And it is becoming obvious. If you look at how they are going about it, for example, today in court, when Mr. Chikata, after it has been advertised at 9:30, all of you were here before 9:30. We were all here before 9:30. Mr. Chikata, for some reason, doesn't show up in court at 9:30. Mr. Letha is the one who comes and then seeks to ask the Supreme Court to stand down the matter while we wait for Mr. Chikata. And the court is like, we've agreed it's 9:30 already, we have to go. And then now specifically, when the court has given an order, the Supreme Court of the Republic of Ghana has given an order that file statements, you say you won't file the statement. So for some reason you haven't filed the statement because you say, because you have an interlocutory application, you are of the view that it will do what? It will arrest the process. When the district court in Ofuase gives an order, you don't do this. High Court, you don't do this. Then the Supreme Court gives an order. And I was making the point earlier that assuming the Supreme Court orders a re-election, you expect the EC to follow that order. But when the court orders you to file your statement, then you say for some reason you don't want to.